Thank you for joining us for this very important interview here on the National Communications Network. My name is Shaquan Gill, and I'm joined by the Attorney General and Minister of Legal Affairs, none other than the Honorable Mohabir Anil Nandlall. And we'll be discussing a very important court decision that was made in the Court of Appeal concerning Elections Petition 88. Attorney General, thank you so much for joining us.
It's a pleasure to be here. Thank you.
AG, let's talk about Elections Petition 88. For those who may not exactly understand what was it really premised on? The case that was filed by, of course, the two people.
Well, you would recall that as a result of the difficulties that GCOM faced in coming to the final declaration of the results of the March 2nd general and regional elections, due largely to the shenanigans of returning officer Mingo at Ashmin's building, a particular course of action had to have been adopted by GCOM. GCOM made a unanimous decision that they will hold a recount of the national ballots. This was bolstered by an intervention by CARICOM and an agreement between then President, His Excellency Mr. David Granger, and Leader of the Opposition, Mr. Bharat Jagdeo. Independent of that intervention by GCOM and the brokered agreement between the two leaders, the intervention by CARICOM, and the brokered agreement between the two political leaders of the country, GCOM, exercising its autonomous and independent powers as the exclusive commission or authority to resolve differences in relation to elections, made a unanimous decision to recount the ballots. In order to do so, GCOM was forced to craft an order that would regulate how it will conduct the recount of the ballots. GCOM had to then find a constitutional authorization and, if possible, any other legal authorization at its disposal to proceed along that course of conduct in order to clothe it with legitimacy and constitutionality. GCOM found in the provisions of Article 162 of the Constitution the requisite constitutional coverage, and also found in the provisions of the Election Laws Amendment Act the requisite statutory cover that would clothe it with the legitimacy to proceed along a course to recount the ballots in order to arrive at a final declaration that reflects the ballots cast. And against that backdrop, GCOM, in exercising those powers, crafted what is called Order 60, which in short, or in essence, is a subsidiary legislation that was intended to regulate how, where, and on what basis the ballots are going to be recounted. And the decision to craft Order 60 and the terms and provisions of Order 60 itself was the product of another unanimous decision of GCOM. I pause here to emphasize or to reiterate how GCOM is constituted. GCOM, as you would know, is constituted by 7 members, 3 from the opposition and 3 from the government, with a chairman having a casting vote. I say that to make the point crystally clear that when GCOM acts and makes a decision, and in this case a unanimous decision, it is all the political players whose interests are represented, and that decision ought to reflect the decision of the political conglomerate of the country, because you have opposition representation in equal number along with government, and then you have an independent chair chosen by a process that involves both the opposition leader and the president. Yeah. The point I want to make is that when GCOM makes a decision, it is the political constituents who make that decision. Notwithstanding the unanimity of that decision and the fact that all the political parties participated in the process, and they participated after several legal challenges were filed and dismissed by those who did not want the recount, and viewers must pause and reflect why they did not want the recount. Though the international community, the national and international observers, CARICOM, and 100 governments across the globe, along with the majority of the local population, all echoed a chorus for a recount of the ballot in order to avoid the attempted fraud perpetrated by returning officer Mingo. Having worked out that process, which lasted for several weeks and had this nation on the precipice, the Order 60 was finally crafted and agreed upon, and the process of the recount commenced. When the process was concluded, as I said, it was observed by the observers that the government appointed. They shut out a couple of observers. You will remember that. They refused to allow the Carter Center to return. They chose a grouping to observe, a grouping emanating from CARICOM. We had asked for the recount to be live streamed. They rejected that. Anyhow, we proceeded to the recount, and the recount was done by GCOM with the observer team appointed by CARICOM and agreed upon by President Granger in particular, who labeled them the most legitimate interlocutors, and the recount was done. When it was realized that the recount did not result in a victory for APNU+AFC, all hell broke loose. The chief elections officer now began to assume a role that was subsequently described by our highest court as, I believe, rogue, and that he can't act on his own, but must act in accordance with the lawful powers, and he must discharge his duties as contemplated and provided for by the law. And that what will matter at the end was all the ballots, and that GCOM, rather the chief elections officer, cannot take it upon himself to determine which ballot is valid and which one is not valid. Those are matters for the courts. Because that is what the chief elections officer began to do in a series of actions, despite GCOM instructing him otherwise. of course, we had several court proceedings in that interregnum. That is, before the final results were eventually declared. Filed by APNU+AFC in an effort to justify the chief elections officer discounting tens of thousands of votes, coincidentally, all in favor of the People's Progressive Party, in his attempt to contaminate the results of those elections. We repeatedly during that period made the point that elections are won or are lost by ballots. Nothing else determines an election. It's what is in the ballot box or ballot boxes. And only the court can determine validity or invalidity of that process. No statutory officer or the commission itself can arrogate unto itself a power to determine legitimacy and legality. Those are matters for the court. And the law is clear how those matters are to be resolved. The election results must be declared, and then whoever is dissatisfied, they have a right to challenge by way of petition. When, as a result of several court orders, including court orders emanating from the Caribbean Court of Justice, our highest court, directing the chief elections officer to perform his functions in accordance with law, only then we eventually got the final declarations done. As I said, several challenges, legal challenges, were filed in the interregnum. After those final declarations were made, and Dr. Muhammad Irfan Ali was declared the president and was invited to appoint his government, and the government was lawfully sworn in, these election petitions came. 2. 1999 of 2022 and 88 of 2022. Of 2020. We will deal with the 99 one a little later.
Yeah, of course.
Today, the Court of Appeal handed down its decision in an appeal that was filed in Elections Petition 88. In Elections Petition 88, Claudette Thorne and Heston Bostwick, obviously on behalf of the APNU+AFC, filed that election petition in which they were challenging a number of things. Principally, they said that the Election Laws Amendment Act was unconstitutional. They said that Order 60 was illegal and unconstitutional, and consequently, the national recount, which was conducted under the Election Laws Amendment Act and Order 60, was unlawful and illegal and unconstitutional. Those were the broad contentions. As you know, the case was heard, and we had volumes and volumes of legal submissions. The case was heard and determined by the Honorable Chief Justice. We essentially argued that the Election Laws Amendment Act, by Section 22, expressly authorizes the GCOM to take certain steps in the face of difficulties to resolve those difficulties. Article 162 of the Constitution similarly authorizes GCOM to do that which is necessary to resolve whatever disputes may arise in order to secure a final declaration of election results at any given regional or general elections. Under the broad cover of those two very powerful, one constitutional and one statutory, GCOM, armed with those provisions, decided to craft Order 60 to conduct a recount. Nothing is wrong with what GCOM has done. Their contention is, or was, that GCOM, by passing Order 60, was usurping the functions of Parliament. Order 60, the Election Laws Amendment Act, which is an act of Parliament, specifically authorized GCOM to do things like promulgating an Order 60 once there are difficulties. Why? One, you have to satisfy a couple of conditions. One, GCOM must face difficulties. No one could have disputed that GCOM faced difficulties at that point in time. Two, Parliament was dissolved. So you couldn't go back to Parliament to pass a law to resolve these difficulties. And thirdly, GCOM, in exercising this extraordinary power, must act within its jurisdiction. In other words, GCOM must perform a function that GCOM is authorized to perform as part of its constitutional mandate. What GCOM did was to recount the ballots. To count and recount ballots is a function of GCOM and GCOM alone. So GCOM was not acting outside of the four corners of its lawful parameters and jurisdictional functions. And therefore, there was no basis upon which they can impugn the validity, the legality, or the constitutionality of GCOM's action in that regard. The law is, he who alleges must prove. If you allege an illegality, if you allege an unconstitutionality, if you allege an invalidity, the burden of proving it is upon you. There are two presumptions in law that operated against the applicants or appellants. One, that there is a presumption of constitutionality, meaning that actions when taken are by public authorities are deemed to be constitutional unless otherwise is established. And secondly, there is a presumption of rectitude by public authority. It's expressed in the Latin term omnia presumuntur rites est acta. Public authorities are presumed to act with regularity when they act. If one is alleging irregular and unlawful conduct, then one has to establish that. Now, the burden of discharging these two presumptions is a heavy one. And both the Chief Justice and the Court of Appeal unanimously found that the appellants abysmally failed to discharge these legal burdens and dismissed the appeal unanimously and awarded costs in the sum of $150,000 in favor of the four parties who participated in the legal submissions, because there were about 13 parties, but not all participated in submissions. The Attorney General participated, Mr. Bharat Jagdeo participated, and I believe the GCOM participated, and one other political party participated in the legal submissions.
AG, people have contended that these election petitions, both of them, were to in some way save face for the APNU+AFC after the losses that they incurred in 2020. Do you share that view?
Well, first of all, I must remind your viewers that at the time when these two election petitions were filed, Mr. Roysdale Ford and Mr. Joseph Harmon, who was the opposition leader at the time, and a large number of APNU+AFC leaders and supporters assembled in the front of the High Court, and in their usual pomp, ceremony, and celebratory euphoria, they expressed the firm commitment to their supporters that within 6 months, by virtue of these two petitions, the PPP government will be removed from office. And there is that is on the public record. The public record will also establish that within 6 months, both of those petitions were dismissed in the High Court. One traveled all the way to the CCJ already and was dismissed in that court. This one didn't make it past the Court of Appeal, and it has suffered a natural death at the Court of Appeal. Whether they will appeal to the Caribbean Court of Justice is a matter completely for them. I don't know about saving face, but they have lost. First of all, you have to begin from the proposition that they had no case in the first place. They have lost the March 2nd, 2020 general and regional elections by thousands of votes. Secondly, recognizing that, they start to hatch theories and allegations of irregularities, that 15,000 dead people voted, that 40 ballot boxes, documents were removed, and they triggered that entire fiasco that the world witnessed at Ashman's building, led by Mingo, the returning officer of Region 4. And when they didn't win that out, when they didn't succeed with that, because of our constant approach to the courts, they reluctantly agreed to the recount. And when they lost that as well, they filed the petitions. So these petitions, in my view, should never have been filed in the first place, because they did not have a case. Yeah. But they filed them. You're saying that they did so to save face. I am saying that it's an expression of, one, trying to play wrong and strong when you have lost fairly. Secondly, to try to derail a process that you have agreed to. They agreed to the recount through their representatives at GCOM and through their president. And when the recount did not produce the results to their liking, they want to break up the whole process. That is undemocratic conduct. That is conduct that strikes at the heart of democracy and fair play. And that is what these persons are. You will know that they have been parroting a narrative that is so outrageous and ridiculous about them being robbed of at the elections. And they do so without any shame, without any remorse, without any show. And they do without any show of any type of hypocrisy. And they do so with great passion and fervor. Notwithstanding that the first elections petition was dismissed, and we're going to talk about that, all the way at the CCJ. And now, this one is being dismissed. And I don't think that this will change their narrative. They will still go out there shamelessly and assert victory at the elections and refer to the PPP government as installed. It's a narrative that is inane and possibly insane. But it is being peddled. And who I feel for the most are the supporters who, for whatever reason, continue to allow themselves to be duped by this narrative and not allowing their rational mind and their common sense capabilities to see through this facade and tell them to their face, look, you have lost the elections. Move on. You will see, notwithstanding this, you go on Facebook tonight and you will see in the ring and out of the ring, and you will hear how they won the elections. These people are living in an alternate reality, and they have persuaded themselves of this own fabricated and concocted reality in which they cocoon. And that's why I say there's a Kool-Aid gang, and they offer this Kool-Aid that they have drank themselves and poison their whole mental system. They administer that Kool-Aid now to unsuspecting supporters of theirs, poisoning their minds as well. Why do you want to keep your supporters in this perpetual state of not only ignorance, but of false hope? That is a cruelty that no Guyanese should be subjected to. And that is what is a mental torture that they are inflicting on their supporters.
AG, if we can take a step back to Elections Petition 99, remind us what that petition was about and why it was cast aside, or even all the way to the CCJ.
Election Petition 99 was even a greater exemplification of their incompetence. Election Petition 99 did not even get off its feet. Why? Because they couldn't even get the service of the petition correct. Now, viewers must understand that election petition laws are unique, they are sui generis, and they are of a special nature. The rules and procedural rules and regulations regarding the conduct are very important and are mandatory in nature. The approach is a different one from any other type of legal proceeding. So it's by a petition. And it has its own body of rules. And there is an abundance of legal literature which explains historically how it evolved and why it is sui generis and special in nature and kind. So the rules regarding its service, its publication in the official gazette, the time for filing, the court to which it must go, the mode of presentation, and all matters in relation and in connection therewith, procedural and substantive, form a body of mandatory rules, and any violation will attract dismissal. The presiding judge is not given any power or discretion to waive breaches. Now that is known to all lawyers worth their salt. To the layman out there, it may sound harsh and oppressive, and perhaps it is harsh, but there's a rationale that is about 500 years old, and it is this: election petitions concern the formation of a government and the composition of a parliament. And a society can't be governed, and the rule of law cannot prevail in the absence of a government and in the absence of a parliament. So matters that affect the composition of a government and the composition of a parliament, by law, must be disposed of in the fastest possible way. And the law, in its wisdom, does not encourage or entertain any infractions of the rules. Any infraction is visited with severe sanctions. That is the dismissal of the petition. Now we have a history of elections petition in this country, dating back to 1968. Every elections thereafter, we have had elections petitions. The PNC is very versed in it. They won many elections petitions based upon those very rules. Same non-service on different occasions. And they benefited from those rules being exercised in their favor. When we raised those objections, I didn't have to look outside of Guyana for case law authorities to support my propositions. I relied on Guyanese cases largely. Of course, I had Caribbean cases of a similar ilk. You have Commonwealth cases all over the Commonwealth, because the law is the same, saying the same thing. And the very cases that the PNC benefited from in the 68 elections, 73 elections, 1980 elections, 1985 elections are the same cases that we used. But they were now on the losing end of the stick. So I want to say to their supporters and to all the people who are saying on Facebook and all the other fora about, oh, we should have allowed the petition to be heard. That is not our duty. Your lawyer's duty was to file your petition and ensure that it is served in accordance with the rules. Those are the rules of the game. So I see this constant argument, oh, you were afraid. What? Afraid of what? You got an opportunity to go to the court, you mess it up. Well, you want me to turn a blind eye? This system is an adversarial one. You take all advantages and benefits that are available to you. They would have done the same if the table was reversed. So I hope people will stop this nonsensical argument about we were afraid of this petition. If you are so incompetent that you cannot even serve your own leader, and you know that's the person that didn't serve. Yeah. They did not serve their own leader, Mr. David Granger. Who you want to blame me for that? You want to blame the PPP for that? You want to blame GCOM for that? That is the rule. Those are the rules of the game. And every respondent in any elections petition is obliged to take advantages of these mishaps and the incompetence of the other side. And that's all that we did. So, I hope now one petition has been concluded at the CCJ. This one is now concluded at the Court of Appeal. I don't know whether they will appeal. It's a matter for them. But the legal system of the country has pronounced conclusively on these matters. The ballots of the Guyanese people were counted. The elections and the recount of the ballots have been adjudged, have been examined, have been scrutinized clinically by the lawful authorities as well as observers. And they have all pronounced in favor of the validity of those elections and the electoral processes. So I hope that, as I said, this narrative will stop unless they want to continue to embarrass themselves, which apparently they have no problem with.
AG, what precedent does this set now? The fact that the courts have dealt with these election petitions, what precedent has this set for elections going forward in Guyana?
Well, significantly, petition number 99 has reinforced the traditional positions that procedural matters in elections petition are mandatory and they must be scrupulously obeyed and complied with. And a failure will result in a dismissal of the petition. So that those historical rules and the court's approach when these rules are violated have been confirmed and reiterated in petition number 99, firstly by the High Court. The Court of Appeal departed from the High Court, but fortunately the CCJ reaffirmed that position. Also, 99 establishes that all challenges to elections results and processes must await the final determination, the final declaration of the results, and must proceed by way of elections petition. 99 has cleared that up. Again, 88 has now formally, by a judicial declaration, recognized and acknowledges GCOM's power, recognizes and acknowledges GCOM's power to take such steps that it considers necessary, expedient, fair, and transparent to resolve disputes and to resolve difficulties and controversies which may arise. It is a power that our Parliament gave to GCOM in the year 2000 when we enacted that law. GCOM didn't have that power before. It had a constitutional, broad umbrella power. But here, Parliament felt that there must be greater specificity and clarity, and we passed a series of sections in that Election Laws Amendment Act to clarify and to make it express and pellucid that GCOM has a power under the Constitution and now under a statute to do that which is necessary to resolve the disputes. Because if not, the society can descend into chaos. Imagine if GCOM didn't have that power. What would have happened in Guyana? An illegal government would have remained in power through fraud? What would have been the international sanctions? You see what's happening in Venezuela? Because of a lack of free and fair elections? They have 10 million people migrating. They have widespread starvation and dislocation and suffering and punishment. Venezuela got population. What would have happened here? In Guyana? We would not have had this. The transformation that is taking place would not have been taking place. This would have been a place plagued with chaos, confusion, and the absence of the rule of law. And that is what the other side wanted. And that is why they are a danger to a civilized society and to democracy. And I hope that the people of Guyana will continue to learn from these processes. The human being, is different from the ordinary animal because the human being is supposed to learn from his or her experiences. We are not supposed to do the same thing repeatedly, expecting a different result. That is why we have what is called a faculty of reason that would inform the way we do things, and we would be guided by past experiences so that we may not commit the same errors again. One last point I want to make is this. We can have the best economic policies, and we can have the best financial arrangements, and we can have the greatest infrastructural projects, all of which we have right now, and the greatest legislative agenda. But if there is the absence of the rule of law, if there is no democracy, if there is no constitutional compliance, all of that would be reduced to nothing. Nothing. They will have no place. They would not even arise. And that's the importance of the rule of law and democracy to modern society and modern civilization.
AJ, I want to thank you so much for taking the time, of course, to have this discussion with us.
Thank you very much.
You heard from the Attorney General and Minister of Legal Affairs, the Honorable Anil Nandlall, and my name is Shaquan Gill, and I'm saying goodbye for now.